Thank you, Mr. Chair. My name is Melissa Wintrow. I'm the Senator for District 19 here in Boise. I also want to acknowledge my House co-sponsor, Representative Wheeler, is here today, and thank him for being here. And thank you all for all the conversations we've had. Senate Bill 1257 is, I think, a very good balance between parental rights and respecting the best interests of children. And simply, it clarifies that mandatory in-person visitation would not be required in cases of substantiated sexual or physical abuse of the child. And there's another piece to the puzzle here too that I'll get to, but it's about what allowing a court to consider when the department initiates termination of parental rights when the parent has been in prison for most of the child's life. So I just want to share a little bit how this is going to go. I see you have a bunch of testimonies already in your notebook. This is a hard topic to discuss. So I know as I've been working on this bill, many stories have come to attention, and they are tough. So I really appreciate you just kind of keeping that in mind as we go forward into consideration of those. The simplest part of this bill, I'm going to talk to you about the mechanics of it. I'm going to yield a little time then to Jean Fisher, who works for the Department of Health and Welfare. When I constructed this bill, I worked with them closely, the Ombudsman's office. I consulted with the courts to make sure no dominoes were falling somewhere else I didn't know about, community partners, foster parents, Idaho Voices for Children, et cetera. So I really tried to involve a lot of people. You're going to hear from some of them, but I'm going to give you the mechanics of the bill. Jean Fisher is going to talk about some of the processes involved in the department for what it means to substantiate a claim of abuse and some of the process thereby. And then you're going to hear from people here today and online talking about just kind of the impacts in their lives. So with that, very simply, if you turn to the bill on page, well, it might be page 6 in yours or 5. Before I get to the bill, let me tell you how I got here. A few months ago, actually in the summer, I got a call or an email from Monique, who you're going to hear from. She told me about some circumstances in her own life as a foster mom that were deeply troubling about visitation being required for the foster children and now the children she's adopted. I myself have been in touch with a few cases in the past that were really heartbreaking, where kids were required to go to visitation when there was a claim of abuse. And it's really hard on the kids, really tough. So we worked over the summer, and it dawned on me what we're talking about really is we already have in rule what we're going to put in statute. So this is a bill putting rules currently that we approved in this body a year ago when we went through the rules and if you're in Senate Health and Welfare, like I know some of you are, we approved those rules and then the legislature voted on them. So I'm taking rules and putting them into statute, and the reason to do that is really to make it very clear for the courts to provide the guidance they need, and I think desire sometimes, of what is the policy of the state. And so we're going to put into code that it is the policy of the state that we will not require in-person mandatory visitation when there is that substantiation of abuse. This is a pretty narrow definition too. It strikes a good balance because as you look down, you're going to see we define physical abuse, life-threatening, disabling, disfiguring. I mean, these are really egregious acts, right? This isn't, I threw something across the room at somebody. These are terrible things, as well as sexual abuse that's defined in current code as well. So we didn't make anything up. We're referencing other sections of code. And then you're going to see here how we substantiate that abuse. And Jean is going to go into that a little bit more. But again, what I like about this bill, it's a good balance. It's not disregarding a parent, because if the department substantiates the abuse and denies the visitation or pauses it, the parent will be informed how they can go through the process to basically appeal that decision. And I've spoken at length to the administrative hearing officer, Brian Nichols, and talked through how that process works. And what's really nice about that is it's quicker than a court, It's not as adversarial, and it doesn't cost the amount of money that a court would cost, and you're going to get a decision quicker. I did check with Mr. Nichols, and he has confirmed that their office has ruled against the department. At no greater percentage as any other department, however, but has ruled against the department at times. What I think is important about this is, as in my time here, in my 12 years, I've seen the department go through changes. And we've seen OPE studies really drawing out the concern about culture in the department and the need for change. And I think the current team has really been focusing on changing the culture, training the staff, making sure that we're addressing some really serious concerns that foster parents have had in the past. And we've seen those bills coming forward for the last few years. So when I talked to Brian Nichols, he also said, look, well, I said, that percentage doesn't seem greater than any other department, but it's good to see you're denying things when you need to. But I'm hoping to see that number go down because the department's improving and training. They're going to talk about that, training their staff and setting expectations and how that all goes. So that's really good. So there's that process that takes place. So I think, again, this part of the code, putting rule into statute, gives the courts guidance. And again, if the person says, yeah, the administrative officer got it wrong, then they can go to the court. And the judge still has discretion to overturn that. Now, if the court decides to do that and force visitation in a case of substantiated abuse, that's okay. The court has discretion, but we're going to ask them to please document that and tell your reason why. And in that case, you'll see safety measures outlined for the judge there too. Again, there are 44 counties. We value court discretion. We value discretion of the judges. But in this case, this is how we can consistently send the message that the legislature wants this to be our policy going forward. And again, I think that provides good guidance to our courts. The last thing I'm going to talk about, and then I'm going to be quiet and let Jean come up, and then we're going to hear from other folks, is on page 7. You'll see 6 and 7, conditions under which the termination may be granted, termination of parental rights. Our state takes that really serious, right? We value parental rights. Currently, as you see in subsection 5, the judge may consider these things when he or she is considering termination of rights. Number 5, it says when the parent's been incarcerated and is likely to remain incarcerated for a substantial period of time during the child's minority. The next thing we're going to add is just to be clear that if the department is the one that brings forward the request for permanency or termination, that the court will also say they may take that into consideration. It's come to my attention that some of the courts have been inconsistent in that. Some courts understand and see the department in that consideration already. Other courts have said, I need to see it in writing. So we're just going to be clear, doesn't require the court to do anything, but they may consider when the department brings forward or initiates the request. And that's really important. Again, we value parental rights, but if I have had a case myself where there was a small baby and the parent was going to be incarcerated for most of the child's life, and that really prevents the opportunity for the child to develop a relationship and permanency in their own life. So we really have to take that into consideration, and you're going to hear some testimony on that. So that's really the mechanics of the bill. I gave you in your packet a copy of the rules that we're putting into statute, just so you don't have to trust me on that. You can see them.